When a blockbuster drug's standard 20-year patent expires, the financial impact is immediate and severe. Generic competitors enter the market, and monopoly revenues evaporate overnight. Pharmaceutical companies rarely get to exploit that full 20-year term. Extensive clinical trials and regulatory approval processes often consume a decade or more of the patent's life before a single pill can be sold. To compensate for these regulatory delays, jurisdictions like Australia offer a statutory lifeline, a mechanism allowing patent holders to recover up to 5 years of lost monopoly time. This details the core requirement under Australian law. Patents must claim a pharmaceutical substance per se or use recombinant DNA technology, joining genetic material from multiple sources. The statute mandates the application involves a chemical interaction with a human physiological system. Furthermore, the patent text must in substance disclose this specific interaction. The active chemical property cannot be an afterthought. It must be central to the claimed invention. The final requirement connects the patent to the physical marketplace. A product containing or consisting of that exact pharmaceutical substance must be included in the Australian Register of Therapeutic Goods, or ARTG. The ARTG is the comprehensive national database of all therapeutic goods legally approved for supply within or exported from Australia. This timeline shows the mathematical baseline for eligibility. There must be a delay of more than 5 years between the patent's initial filing date and its earliest ARTG registration date to qualify for an extension. Securing an extension worth hundreds of millions of dollars relies entirely on locating the exact legal boundary between a delivery mechanism and a pure chemical substance. Australian courts enforce this chemical boundary with absolute rigidity. We see this strict application clearly in the Boehringer-Ingelheim decisions. This document outlines Boehringer's patent for Atrovent, a container holding an aerosol composition. The federal court rejected the extension. The logic was precise. A physical container, even combined with chemical contents, does not constitute a pharmaceutical substance per se. This legal doctrine was tested against an even more complex delivery system in the LTS-Lohmann case, regarding a transdermal patch. This diagram illustrates the patch's sophisticated physical engineering, designed with distinct layers for the controlled release of 17-beta-estradiol. The examiner refused the extension on 2 prongs. First, the deliberate spatial arrangement of the backing and release layers disqualified it as a simple mixture. Second, lacking chemical bonds between the physical components and the active ingredient, it was not a compound. This precedent dooms other physical delivery systems. Mundipharma's buprenorphine patch was refused, partly because its claims included physical instructions, and Sanofi's Stilnox bilayer tablet was rejected due to its physical release layers. The Australian legal system views physical engineering as entirely distinct from the chemical substance itself. No matter how medically vital the delivery device is, it is ineligible for a patent term extension. While the physical definition of a drug is narrow, patent strategists find success by shifting their focus to the textual requirements of the patent claim, specifically looking at the exact phrase "in substance disclosed." This strategy was utilized by Pfizer during their attempt to extend an earlier generic patent for the antifungal agent voriconazole, marketed as Vfend. The legal tension centered on the text. The earlier generic patent technically encompassed voriconazole, but it didn't specifically describe the exact compound in its text. This diagram illustrates the federal court's ruling saving Pfizer's extension. They determined the in substance disclosed test is a lower, more forgiving bar than the traditional fair basis test. Fair basis is a strict legal standard requiring the scope of a patent's claims to exactly match the specific invention described in its text. The Merck case involving the drug lovastatin demonstrates how this textual loophole applies to chemical reactions occurring inside the human body. Merck requested a patent extension based not on the originally administered drug, but on a specific metabolite of lovastatin. A metabolite is a substance formed during metabolism, often the byproduct of the body breaking down a drug. Merck successfully argued that because the human body's only reasonable use of lovastatin inevitably produces the claimed metabolite, it triggers contributory infringement. Contributory infringement happens when someone supplies a product knowing it will be used by the recipient to infringe a patent. The extension was allowed because chemical analysis showed the registered export product contained just 0.2% of this specific metabolite. While the physical definition of a pharmaceutical substance remains rigidly narrow, the textual interpretation of what a patent discloses allows strategic maneuverability for broad generic claims and secondary metabolites. Moving past chemical eligibility, patent holders must navigate the rigid mathematical formula that dictates the actual length of the granted extension. This presentation slide outlines the exact calculation formula. The extension term is the difference between the earliest ARTG date and the filing date, minus 5 years. Pfizer initially secured extensions for the drugs Norvasc and Replax based on the dates of their first domestic ARTG registrations. However, they fell into an administrative trap. The Commissioner of Patents later discovered earlier export-only listings for these specific drugs within the ARTG database. Australian regulations empower the Commissioner to formally amend the patent register if earlier inclusion dates are discovered after an extension is granted. This chart illustrates the devastating legal impact. The full federal court confirmed that export listings count as the earliest valid date, radically shrinking the available timeline. The final consequence for Pfizer was severe. The terms were reduced by 10 to 13 months, and in the case of one patent, the extension was reduced entirely to 0. A chemically perfect patent strategy can be completely neutralized by a failure to audit historical export-only administrative filings. To fully understand the strictness of the pharmaceutical regime, we can contrast it with Australia's treatment of agricultural biological intellectual property. The 1994 Act established plant breeders' rights, or PBR. These rights are a form of intellectual property, giving the holder exclusive marketing rights to a registered plant variety for up to 25 years. Baseline PBR protection covers the initial propagating material of a registered plant variety, such as a simple seed. This split-screen diagram compares the two systems. On the right, PBR protection expands outward to include the entirety of the harvested material, and even further downstream to commercial products derived directly from that harvest. Contrast this expansive biological protection with the pharmaceutical framework on the left. To qualify for an extension, the Pharma patent must shed its physical delivery mechanisms to isolate the pure chemical substance. Agricultural law protects the downstream physical results of biology. Pharmaceutical patent extension law protects only the core chemical catalyst, actively discarding the physical delivery mechanism. Australian intellectual property law forces pharmaceutical innovators to operate in an incredibly narrow, reductive exclusionary zone. Precise statutory interpretation is the single most critical factor in determining a drug's commercial lifespan.